and we're not doing it right. Next. So our role in the Pew Project, which you'll hear about momentarily from Suzanne, let me back up. So one of the primary projects of Stewards of Change is something called the National Interoperability Collaborative, NIC. Many of you know about it, maybe all of you know about it. And NIC is a community of networks. It is that community of networks that makes us important to this project, I think, because our role is to look at what technologies, what processes are being used in banking and medicine all over the place that the courts do not know about or are not using well enough. So we are looking at all of those and infusing the Pew Project with some knowledge of what can we learn from other realms that is relevant, that could improve processes, equity, and other aspects of the civil courts. So that's the steward's role. And you'll be hearing more about that in the months to come as we come to fruition on that work. Keep going. So we're showing you this slide, social determinants. It's in the headline of the symposium, you know, what it's all about. Keep going. And when we look at the social determinants, what you don't see we've all come to know this term fairly well, what you don't see is the courts. And so what we're suggesting, next slide, is that they belong there. That we start thinking, I'll go to the last bullet first, that we start thinking about the court role in furthering the social determinant, in integrating with the social determinants, because again, housing is the easiest example, but almost any example you come up with where people wind up in civil court, there's been some intersection with where they live, where they work, all that social determinant stuff. And yet we don't think about the court role. And I will say the converse is probably usually true. The courts don't necessarily think about their role as a factor in the social determinants. And so we're suggesting that that's an important paradigm shift that we accomplish, that we start to instigate as we do this work, understanding that they do have a role and they are integral to the social determinants. And as we were thinking about all of this, interestingly, just a few days ago, I have it here, actually, it was on January 12th, the ACF put out a letter, and this speaks to my point earlier, a little while ago during the main session, that, you know, this is bully pulpit stuff. They're saying the various aspects of the new administration are saying what's important, how should we be looking at the world? And this one was particularly interesting and relevant to what we're doing today. I'll read it. It's the only thing I'll read off a slide. The purpose of this information memorandum is to highlight the importance of civil legal advocacy in advancing child and family well-being, addressing the social determinants of health, enhancing community resiliency, and to strongly encourage state, territorial, and tribal human services entities to work together to support access to civil legal advocacy. So it is civil legal, the civil legal world is important to the social determinants, it's important to children and families. And I think that it is a real mark of what we can accomplish in the days and months going forward to help integrate those aspects together. Keep going. And these really make the point of the intersection and the cross currents of courts and social determinants. I'm not going to read them all to you, but they're all about the challenges courts face, and they're very much grounded and rooted in the social determinants. I think you'll agree. And please type into the chat if you agree, disagree, have examples. Again, please use the chat freely during the course of this. Actually, do me a favor, Gillian, go to the next to last slide. I'm going to go out of order because I don't know if we're going to get to it, and I want to make sure I say something about it. Whoops, not yet, not yet. Can you not get to it without?
I think that's going to be hard to do.
Oh, it is.
Oh, yeah. There you go.
Oh, there we go. Okay. I just wanted, because I do want people to go into the chat. Here are some of the questions. Please think about these as we are going through the presentations today. Do you know of technologies we should be using? Are you using it? Have you used one in your work outside the courts that might be relevant to our work and that we should know about? Is there something that you think, have an aha moment as you listen to everyone today and say, that's what we could start with, that's what we could do? And so please think about those things. And then we are starting this work in New Jersey with Inc. in the state and have interest in other states. So I expect we'll be doing other work. But please, if as we go on, if someone instigates a thought, they could do something with the courts in X, Y, in your own jurisdiction or in your own work, we would like to hear about it. And with that, I wanted to, if we go back up, we're going to hear from Judge Capizzi as best as we can. And then Suzanne, if you could just, when he finishes, rather than spending time with an intro, Suzanne, if you could just pick up after he's done.
Yep.
Uh-oh.
Volume.
Uh-oh. Anybody here?
Nope.
Nope.
No.
Leanne, we're not hearing it.
Gillian, I want to suggest that why don't we stop it and move to Suzanne, and if you can work on that or get some help on that, maybe we can get back to it.
Oh, what was the problem?
We can't hear it.
Oh, you can't hear it at all?
No.
Oh, all right. That's odd. Okay.
No. We tested it and everything.
I know. I don't know why. All right, I'll go to the next slide.
Yeah, please, and see if we can work that out and get back to it. The capsule of what Judge Capizzi has to say is the courts have some real work to do. And one thing that I'll say that I don't remember if he does is that there's one of the, I think, fundamental things that we have to think about is whether the paradigm that is in place with the courts is the right one. That is, court processes, technology, they're made to serve the people.
Hi, everybody.
They're made to serve the people who run the courts, and do they really need to be about the people who use the courts? With that, Suzanne, do you want to jump in?
Sure, I can jump in really quickly. Hi, everyone. I'm Suzanne Brown McBride. I'm a consultant working with the Pew Charitable Trust, and I wanted to give you a little bit of an overview of Pew itself, just for context, and then some of the reason why Pew has chosen this as an area that we're interested in terms of making investments in social change. So if you could go to the next slide, Gillian. So just a bit about Pew. Pew is a public charity, and the difference between most public charities and other types of granting organizations is that Pew actively engages and has its own workforce that does work in the areas that they choose to work in. And so we're a public charity that's driven by knowledge. We do fact-based research and rigorous analysis. We help states apply that research to a wide range of policy areas. And so anyone who is a public radio listener has heard of Pew in terms of its environmental work, but we also do work in health and consumer safety, as well as state policy, economic issues, and criminal and civil justice. And so this is one of the areas that folks have identified as an important piece of what we're doing. So if you go to the next slide, let me just give you a little bit of background that would have bookended Judge Capizzi's observations, but let me see if I can give you a little bit of context. A lot of us who have worked in the justice space have spent a lot of time talking about criminal justice reform. And it's been something I think all of us have seen on the news and heard out in the world. This project is focused specifically on civil justice and on the civil justice system. And it's a system that over 30 million Americans each year will encounter, and most of them will encounter that without a lawyer. Unlike on the criminal side, where there's the Gideon Doctrine that says that every indigent person deserves to get representation in a process, that is not true on the civil side. So for the vast majority of those 30 million people, they will not actually ever have legal representation to assist them with their claims. Can you go to the next point, please? And actually, just go ahead and go all the way to the bottom of the slide so we don't do this each time. So, so they receive little information or little assistance in court processes. This could mean everything from paperwork. And so when we're talking about like civil issues, we're talking about divorce, child custody, bankruptcy, debt, things that are massive, massive implications for people who are living throughout this system. The results in all of this in terms of not having representation, not necessarily understanding what they're doing in the system, and not necessarily fully understanding the implications of the legal issues in which they're entangled with could mean higher costs for courts, for litigants, people that are often deprived of their day in court, or even more importantly, people who don't even show up for their day in court. If you follow some of the work that Pew has done in terms of debts and debt negotiation, what we've seen is that more often than not, people simply don't come to court to be able to contest their debts. So literally judgments are made against them, whether or not those judgments were legitimate or appropriate, because they simply were not able to effectively engage within the system itself. And so because of those kinds of issues, nearly everyone in the system agrees that there needs to be greater fairness and efficiency, but there's not a lot of a consensus on how to get there. And so that's part of why Pew is engaged in this process. So if you go to the next slide, please. You know, just to give you a little bit more detail, 71% of low-income households experienced at least one civil legal problem in the last year: debt, eviction, foreclosure, child custody, disability claims. Next, please. And most of the problems that low-income Americans
Sorry.
face are the result of inadequate. They get no legal help, or they get no ability to go through. That doesn't mean that their court systems aren't trying to do some level of self-help, or that there aren't some systems that are designed to assist folks, but that these are actually very, very scarce resources and difficult to have. Similarly, there are obviously attorneys and folks that do work on the civil side. Those are also scarce resources that are difficult for people to get. You could go to the next, please. It's also, I think, the dilemmas that's happened both on the criminal justice side and the civil justice side have changed how people have been perceiving the courts. While most people seem to still have faith in the court system, that number continues to drop. You know, and 65% prior to 2019 had confidence in the court system, but that's dropped by over 11%. You know, a significant number of people believe that that agree that there are two systems of justice in this country: those that sort of have resources and representation, and those that don't. And that they don't, and you know, and despite the fact that particularly the civil system, most people will end up having to represent themselves, most people don't think they could adequately represent themselves, regardless of, you know, the information that's provided. You know, when all is said and done, the civil legal system is designed by lawyers for lawyers, and people who don't have that representation really oftentimes struggle to navigate that system. And then 57% of the community said that judges don't reflect the values of their communities or understand the challenges of people in their courtrooms. And so that disconnect is another thing that causes people to have a difficult time engaging and connecting with that system. And so all of those reasons, if you could go to the next, please, are the reasons why Pew has started to engage in civil legal issues. Pew has chosen sort of principles that frame our work in this area, which is a court system, a civil court system that is open, efficient, and equitable. And that what we're hoping to do under the banner of those principles is to research ways to improve health, housing, and financial outcomes for people involved in the civil legal system, to build partnerships with the private sector policymaker and stakeholders, part of what you're helping us do here today, as well as develop and promote promising technologies. Like, this program has a focus on sort of how technologies can help us get people better connected, to get them more equitable justice, to use technology and infrastructure to make data around the court system more open. And so this is one of the conversations that we're using to inform our work. So thank you, and looking forward to hearing your feedback.
Jillian, how are we doing on the video? Do we have it or no?
We're gonna wait until after Paul and Kay present.
Great. Okay. If Paul, please take it away.
Thank you. And thank you, Suzanne, for introducing the topic. I want to start this off by noting that even this morning, the Washington Post primary editorial was an introduction to this discussion. The Post reported on a study in Baltimore recently that showed that in the dealing with the topic of eviction in the courts that 96% of the landlords had a lawyer, but less than 1% of the tenants had a lawyer in those cases. And it just, really puts the nail on the points that Suzanne made so eloquently, that the civil justice system is designed to facilitate solutions on the part of those who can afford the lawyers to present their case, and not on those who are affected by the outcomes. Yet we know that what we did to create the civil justice system, or collection of processes, I really hesitate to call it a system, but it's designed to level the playing field between those who are capable of employing lawyers and those who aren't, but to really provide, as the name implies, justice in cases where fairness and equity should be the principles. So if we move forward on the point that Suzanne made so well, that we really don't have a system that's well balanced. We need to take a look at what the perceptions and needs are of what I like to call the clients of the civil justice system, the people who are most affected by it. And in the focus groups and the meetings that we've had so far, we've identified three kind of fundamental questions that are not well answered by the current systems of civil justice throughout the country. And these are the three questions. What are my rights? People don't really know what their rights are in many cases, whether it's an eviction case or child custody or debt. People are unaware of their rights to use the courts to obtain a just and fair, equitable outcome.
What's going on?
The second question is,
Can you fix that?
where can I?
Paul, I'm going to interrupt you for 30 seconds just to say that we only see your forehead. If you could more look up at the camera, that would be great.
Not good.
Oh,
Okay.
Thank you. And Daniel, we can hear you.
Yeah, I just noticed that we may be busted out of
Are we being
these.
kicked out now?
Well, okay, I think that the right number of people are here.
All right. That's a miracle.
That was interesting. Okay, Paul, you're back on.
Can you see me better now?
We can, thank you.
Okay. So the three questions again, that if we take a client-centric view of how civil justice ought to operate, we need to answer these three questions. People need to know what their rights are. They need to know where they can get help, what kind of help is available, both from the courts themselves and from legal services that are available to help. And then how do they interact with the civil justice system? Because as Suzanne mentioned, a lot of the issues have to do with the confusion over what forms to follow and what processes to follow and how the civil justice system even works. Next slide, please. Let's take these one at a time and talk a little bit about this issue of how might technology be helpful in improving this operation of the civil justice system. When we start with the question of what are my rights, there's an enormous need for more educational resources to be able to explain to people who may need the help of the civil justice system in order to right a wrong or to deal with an accusation, or even to deal with legal issues like the rights under eviction or what have you. Educational websites, of course, abound all over the country. There are lots of people who attempt to document this, but there's no really coherent, cohesive approach on a national basis to explain people's rights for a variety of issues upon which a need to interact with the civil justice system might be based. We have some YouTube videos that have been made. So of course, there's plenty of case stories out there that could be used to create more YouTube videos that in a systematic and logical way represent an explanation of the rights people have in all of the situations in which they might find themselves involved with the civil justice system. including testimony from those who have faced those issues and worked them through with the courts. And putting those case stories in terms that the typical client who doesn't have a lawyer to represent them needs to understand and find useful in terms of how to deal with the system. Certainly, there's a potential for selective notification that's triggered by events that would automatically trigger an invitation to subjects of the criminal justice or civil justice processes to engage the courts in solving their issues and problems. I'm thinking of things like in the criminal justice world, the victim notification services that have been automated throughout the country to notify victims when the perpetrator of the crime for which they are a victim is being released. We have those kinds of notification systems. So the next question that clients really ask is, where can I get help? We've talked about, and you heard a little earlier from Daniel and others about the possibility of using 211 as a way to provide referrals and information to people needing legal help or needing to access the capabilities of the courts to help resolve their problems. 211 is growing in popularity throughout the country and is a very effective referral service. We've seen evidence in San Diego, for example, in connection with the Community Information Exchange you heard about earlier, that over 600 different organizations have come together to mutually refer clients to find the needs that they have most appropriate to solve the problems that they're seeking. There's very little 211 services that I've been able to find that really incorporate the idea of providing access to legal services as well as other typical services like housing and food services. We have some experience building portals to identify resources, and some of the work that Pew has done and some pilot projects have been focused on this issue of providing portals that people can have access to ask the question about where can I get help or how can I get help. There's also, some courts have expressed an interest in providing proactive notification to the claimants instead of waiting for the case to be filed and the court date to be set and then notifying people that have to come to court to resolve their issue, of notifying them automatically upon the initial filings and the initial even discussions of possible issues. And then having those referrals be automated so that there is a capability where it's possible to actually identify and notify people that there are legal services available to help them to the extent that they are. That's, to me, not necessarily a good solution because the availability of legal services is so limited throughout the country. And then the final.
Paul, I just want to say you have a 2-minute warning, just so we have time for discussion after Kay speaks.
I got 2 minutes left.
Yep.
The final question is, how do I connect? And that's really, there's a lot of work that can be done by technology to simplify the forms and the applications for getting services and support and dealing with the filing requirements that courts have laid on that make this process so complex and difficult. And providing that interactive chat-based communications and teleservices as a way to have access to the courts instead of providing that, requiring everybody to drive on down to the courthouse and appear in person to do everything. And of course, there's a lot of room to expand the electronic filing of all required documents as opposed to requiring written paper. And then there are just a set of principles that we need to be looking at on the next slide when we start thinking about this technology, Gillian. And I'll quickly mention these. We need to start thinking about becoming proactive in providing legal services, not reactive and waiting for someone to file a case and require appearance in court, making the whole civil justice system more client-centric in all of the processes that we build, basing the developments of new systems on what the people need. That's again involving the inclusion of people with lived experiences and building metrics and data systems to document this. These are the kinds of principles that have to be formulated and expanded upon as we build out the use of technology. But the real key issue about moving forward with applying technologies is not forgetting the human element, because it's going to take building a connection, a partnership with those people who need the services with the courts to take their views into consideration. And unless we move forward on the human factors, the technology itself is not going to be sufficient. And to explain more about how the human part of this applies, I'm happy to introduce my great colleague, Kay Chapard.
Thank you, Paul. Can you all hear me? Oh,
Yeah.
okay.
Yeah,
Yeah.
we're good.
Okay, great. So yes, my focus is a little bit more about on that human interaction. And I saw in the chat at the beginning of the session that there are some folks on the call who have a background in the criminal justice system, which is a little different, obviously, than the civil. But I think one of the things, and I have worked a long time in the criminal justice system myself, as a prosecutor and also in private practice doing indigent defense. But in those cases, there's a right to counsel, right? And in the civil arena, that's not true. There is no right to counsel. And so we listen to what Suzanne told us about, 96% of landlords are represented by counsel and 1% of tenants are represented by counsel. So that's very telling that this is a dramatic issue. And I think Paul did an outstanding job talking about all the technologies that are potentially available and we could bring to bear, but getting to that place is a whole nother story. So I've sort of broken up my comments to you, and I can tell this is a very experienced audience, so hopefully some of this will resonate with you and has been your experience, sort of talking about the attitude and what it is we're trying to address. And then what we need to do before anyone ever gets to court or knows they need to, and what we need to do when we actually get into court for some of these users who are typically, as Suzanne pointed out, people who are not represented by counsel, right? So these are self-representing litigants instead. So the first thing, and we have touched on this as well, is we really need to work to develop the trust and to build up respect for this community and their trust to trust the courts. And that's tough. One reason is past messaging. And again, we saw some of the statistics, right, where many of these people with lived experiences feel like the courts are not for them. They're for rich people, they're for white people, they are not for them, and that they don't have a sense that they can be helpful. And, feelings in these communities often of hopelessness and helplessness. And these things have a huge impact that I think sometimes those of us who've been officers of the court, no matter what your position, have not wanted to address. We've sort of just tried to set that aside and been kind of like, well, that may be true, but I'm just the court system. We can't address those things. If you go back to Adam's opening remarks, and we saw this chart about all these social determinants for health, and he pointed out that the courts aren't really listed, but they should be. And I would like to commend all of you who work in the court system that I think we need to rethink our roles. And at a certain point, we can't just keep saying, well, that's not our role, that's not our role, that's not our role. We've said it for decades. I think we have to get over it and move on, because in fact, it has to be part of our role. And what we do makes a huge difference in quality of life. And we just have to be able to take that on and say, okay, so what can I do from my perspective? When I talk about respect here, I'm talking about the court system respecting the self-represented litigants, okay? The respect that we need to make sure permeates everything is our respect for people with lived experience. We shouldn't try to second guess. We shouldn't try to tell them what they should do or think or anything else, right? We should respect them where they are. And worthiness is also something that I think we need to develop in this audience, their sense that they are worthy of representation, of having their day in court. They are worthy of our respect. They are worthy of us protecting their rights. So the most important thing about all of these is that once you build that up, and I hope you have and will, we have to be careful to maintain it, because it is easier to build trust than to restore it once we've broken trust. If we could go to the next slide, because I know we don't have a lot of time. I just have a couple more points. So the other thing I wanted to focus a little attention on is when we're talking about, the use of technology, which, in some ways, the pandemic has been a blessing in disguise, in that many of those folks who work in the courts, judges, their staff, all kinds, have now discovered that there are things that we can do remotely, services we can offer that we never would have said we could have in the past. So it's been eye-opening to see that perhaps we're capable of more than we thought. So that's a good thing, despite all the other bad things. But before anyone needs to be called into court or wants to take something to court, we have to begin to educate the public. And some of that is education about that certain behavior is unacceptable and may also be illegal, so that people are aware of their own rights. Educating people to recognize that everyone deserves their day in court, and that's everyone. That it doesn't matter race or social status or anything, everyone. And that's something that we need to try to overcome, of an attitude that maybe it's not for everyone. And I think that the courts have to have a leadership role in that, if we're going to have anyone really listen to that. The other thing is that we need to find ways to provide this information. And I know people talked about the fact that internet access is very difficult in some of these communities. And so it's great to have these technology solutions. How do we, begin to be able to use them? And I know that I'm not going to try to answer that people, that there's a quick and easy answer for how you get that internet access. But I think some of it is using services, using people, institutions that may already be working in these communities. So, and provide written notices, provide graphic messaging, provide written notices that are more language diverse, depending on the communities that you serve, that really let people know this is what's out there. Here's where you can go for help, and those kinds of things. And I talked with some folks about that. Part of the reason I also think you should think about going to trusted people in the community. I'll give you an example in my own personal life. My sister-in-law works at WIC, which is Women, Infant, and Children. And they're providing services through the pandemic, trying to get them. But they are people, frankly, that have the confidence in many ways of the people that they serve. So some of those people with lived experiences already are coming there for services and for help. So if we could augment that and provide them more information, that's a simplistic example. And you have to, I think, tailor this to your own communities. But I think that we sort of get a little bit of credibility just by the fact that they have credibility, if you will. So anyway, if we could go to the next slide. So my point is really that in all of this, I hope you can see that our focus really needs to be on what I call the users of the system. But the system users, in this instance, I'm not talking about judges, I'm not talking about attorneys, I'm not talking about the clerk of court and all of those, really talking about those people that have to represent themselves, that have either been called into court or need to right or redress a wrong that has been committed against them. We need to try to find a way to make the focus on them. And I think sometimes it is harder for those of us who are law trained to take a step back and realize the way that we have historically run the courts, if you will, what our philosophy or focus is, because a lot of it is cultural, it's systemic, it can be hard to see unless you take that step back, and most of the time, I think, at least for myself as a lawyer, I think we focus on what does the judge want? How does the judge want to do this? How does the judge? need me to do whatever my job is. And instead of doing that, I'd like to encourage you to consider turning the system on its head and instead focus on, what do the users need? What do they want? What are the gaps that they are facing? And figure out how we in our performance can meet their needs instead of being concerned about the constructs of the way that we set up our courts. And I know that we have, I know Judge Mack was in this group, and she had previously worked in the juvenile and the family court area. In some ways, perhaps they've overcome some of those barriers, but we need to do that system-wide. And as the final things that I have, once you're in the court process, the people with lived experience need to feel that trust and respect is embedded in that process. We need to meet them where they are. I encourage you to find new partners in the community. I think, as we mentioned before, these are great technological solutions, but if it's not something that the users can actually access, then they're not as helpful. I think we have to reassure our users that they're worthy of being represented, that they don't have to be treated poorly, and that we are there to respect them and trust them and honor what their needs are. So, my last word there is, don't break their trust. It's hard to do. It's hard to come back from that. So I think most of the things I'm saying are common sense things. I see there's comments in the chat. I didn't have a chance to read them while I was trying to go through this, but I know it's a very experienced group, and I think it's important that we look at these systemic issues as we're at the same time trying to address the possibilities that technology can offer. Thank you.
Great. And I would add that technology can also help deal with some of those systemic issues, right? So do we have Judge Capizzi lined up, or can we do that, or no?
Yeah, let's try it.
Let's do it.
If I can get out.
Then I'll jump into the closing of this.
Sorry. All right, let's try it. Let me know if you can't hear it.
Hi, everybody. I'm Judge Capizzi. I'm a presiding judge over the juvenile and family court system in Montgomery County, Ohio. I'm really sorry I can't be with you today. I'm actually doing my real job today, and I have a trial of a major case dealing with child custody. For years in this country, we have really had a justice system that works for lawyers, that works for courts, it works for government. Or our justice system, especially our civil justice system, is supposed to work for the citizens that we serve in this country. I've seen too many cases over the years where people are afraid to come to court, or people simply don't understand what it means to go to court, or they can't take off of work to go to court. And so in those cases, technology like this can give them access where they've never had before. We always lose track. We think that the legal system is just a legal system. But in reality, our legal system affects the health and safety of our citizens and our communities. And technology has given us an opportunity to give more people access to our court to make sure we can accomplish the goals of what a court needs to do. We need to be fair, give equal justice, and make sure at the same time we manage the individual's needs. With the challenges of COVID, it's forced so many courtrooms around the country to look to the opportunities available to use technology in courtrooms. And I think you're finding technology we've been forced to use for the last now 8 or 10 months will have long-term positive effects for justice in this country. I really believe that if we do it properly, but technology and the acceptance of technology by court systems around the country can do a much better job of giving access to justice for all citizens of the United States and frankly, non-citizens. And there are many courts that are pushing back, quite frankly, because they just don't want to change. But the reality is, in many ways, our society is changing, and the court system must change with it. I want to remind you one of the reasons why we're here. The National Action Agenda has really been a focus of Stewards of Change, the Stanford University, and really with help from many foundations to try and find ways to make sure we advance social determinants and health equity.
Great. Great. It was as though we put it here on purpose, right? Can you jump we're going to wrap this up, and we're actually in a very good place, because I think what Paul, Kay, Judge Capizzi, what everybody is agreeing on. I don't see slides.
Hold on one second.
I see your picture, which is nice, but well, I'll just well, here we go. So this quote, interestingly, I think really affirms what everybody has been saying. This is a theme that Gillian and I, doing focus groups with this Pew Project, have heard over and over and over again. I just had to choose which quote I would use. No one is informed of their rights, and the litigants themselves are traumatized. It's people who aren't in good situations trying to navigate a system that is not built for them. That, as the judge said, as Kay said, it's really built for the people who run the show and not for the people who attend and who are supposed to be served by it. So the communications in terms of learning, we are learning, is just something that must be dealt with in a big way. I think that what Judge Capizzi said is really right on, and this speaks to your point, Kay, about turning things on their heads. The pandemic has really forced courts to use Zoom, and that's probably A, B, and C, right? Because the court is coming to people, and they're not. It can't force people, in most cases, in many cases, cannot force people to come to court, and that's a real game changer if they stick with it, if they don't keep pushing back. And that's the beginning of that change, which again leads to the I'm looking for where I'm looking. Okay, the third bullet, which is changing the paradigm so that it's really the users who are going to be the beneficiaries of the process, and not how do we make this process so the lawyers can be there on time, so the judge gets his docket straight. How can the users be served? And that's really the search that we've been doing, looking for technology. To the fourth point, there are just a few examples. To the fourth point, that there are technologies, and Zoom is probably first among them, that can expedite that paradigm shift, which I think we all probably agree would be a very big and important thing, and would force us to deal with the people with lived experience, who we all say are the ones we should be listening to. Last slide. And I think we only have a couple of minutes, but so I'm going to leave these up, but leave it open to anybody who wants to speak up. Does anybody want to address any of the issues that we have put on the table here? I think they're really important. It's not just about technology, as both Kay and Paul said. It's really about how we treat people and who the primary focus of this effort need to be. And I'll leave it at that and ask if anybody has any parting words on the panel, or whoever else is participating. A lot of chat.
This has been really enlightening in terms of just really thinking about, the folks designing the system are the ones who sort of are being served by the system, and it's leaving out the people who are meant to be served by it. And I think the same actually just applies even to every step of the technology, just making sure that the experience of getting and using the technology you need for court is not as painful as the process of the court itself has been for the people it's supposed to be serving.
I'd actually be very curious. How did that come about? How did this system come about? The people who are very involved in it, who are on this call, the users became subservient to the people who are running the show. How does that come about? What is the attitude? What is the history that led to that?
Well, Adam, the original users of the civil and criminal system were attorneys and lawyers. People with legal problems were never considered users of the system. And that's sort of, and Josh, to your point, Joshua, the point that you just made, it's an interesting one, because it in fact impacts how all of the technology systems in the stack have been made, right? If you look at technology and court innovation, if you look that up and just start to Google it and poke around, what you will see is a lot of technology aimed at the courts: case management systems, kiosk management systems, information management systems,
Right.
all which are super important. But this idea of citizen as user is my folks who are closer to the legal construct than I am, can disagree with me if they think, but that tends to be the thing. Like, the users really were like these professional actors in the system that had clients, but everything was geared that way.
Well,
it really follows the money, in my view, because the people who have the need for the services are not providing the funding. It's the people who have to run the courts and deliver the services who are paying to have systems built and paying for technology. And it's kind of almost a natural evolutionary step to say that the systems that are designed to serve those that have the money to spend. I wish Paul Embley would say a couple things about what the National Center for State Courts is doing about all this. Are you still on, Paul?
Yeah, I am.
Yeah.
Thanks for the shout out, Paul. And I would say that all the stuff that we're doing, Pew is funding a lot of it, but there's many others that we're partnering with, and we're always looking for that magic bullet. We haven't found it yet, so we'll just take all the small wins and the ideas that you all are coming up with definitely will find their way into some of the work that we do.
That's great. Gillian, if you would go to the last slide, we can wrap it up by just pointing out the work that we are starting to do in New Jersey. Anybody who's gone to the first session knows that that's where we are starting to plant the flag first. It's important to say that the work that we're doing is not only for and about New Jersey, but you got to start somewhere. And the whole idea of the action agenda is that we are going to start implementing. And so the work to do with the judiciary, just as with the other action recommendations, I'm watching the clock here, I have 38 seconds. The work we're doing there will be a start to this, but just as with the Thompson family that you saw earlier, the idea is not just to solve the problems of the Thompson family, or is it to solve the problems on the ground in New Jersey. It's to build systems and approaches that we can then transplant elsewhere and hopefully do some good work that's more systemic. And with that, I think we have like 10 seconds. Thank you all so much, especially the presenters. Thank you all for attending, and we hope this was a useful session for you all.